mobile devices. We do have a very full agenda today, and I want to get started as close to on time as we can. Just to set the stage, we have a relatively large amount of committee members on this joint committee meeting between the state and local government committees in the House and the Senate. We also know this meeting has been opened up to members who are not members of the committee as well. So for those members who are attending but not members of the committee, if you have questions during any of the presentations, if you could please funnel those either to me, through another member of the committee, or to one of the staff members, either through the chat function virtually or in the room. We would appreciate that as a way of just controlling the flow of the questioning and keeping everything on a time schedule. I'm going to turn it over to my co-chair, Senator Robbie Mills, to get started on the State Government Committee.
Madam Clerk, if you could call the roll for the State Government Committee.
Senator Alvarado.
Present in the room.
Senator Harper Angel. Senator McDaniel.
Remotely in the district.
Was that Senator Harper Angel? Thank you.
I'm
Thank
present
you.
in the room.
Senator McDaniel.
Present in the room.
Senator McGarvey. Senator Nemes.
Present in the room.
Senator Schroeder.
Present remotely.
Thank you. Senator Southworth. Senator Storm.
Present in the room.
Senator Thayer.
Here in the room.
Senator Wheeler. Representative Blanton.
Present remotely from my district.
Thank you. Representative Bowling.
Present in the 87th district.
Thank you. Representative Cantrell. Here in the room. Representative Decker.
Present in the room.
Representative Duplessis. Representative Fisher.
Remotely.
Here in the room.
Representative Flood.
Present from the 75th district.
Thank you. Representative Gooch.
Present in the room.
Representative Graham.
Present in the room.
Representative Heath.
Present in the room.
Representative Heverin.
Present in the room.
Representative Imes.
Present in the room.
Representative Johnson.
Present in the room.
Representative Cook.
It is off.
Representative Derek Lewis.
Present in the room.
Representative Scott Lewis.
Present in the room.
Representative Maddox. Representative Meeks. Representative Mentor.
Present in the 20th district.
Thank you. Representative Moser.
Present from my district.
Thank you. Representative Nemes.
Present in the room.
Representative Scott.
Present in District 41.
Thank you. Representative Smith.
Present in the room.
Representative Stevenson. Representative Tate. Representative Tipton. Representative Upchurch.
Present in the room.
Representative Weber. Representative Wheatley.
Here in the room.
Representative Bratcher.
Here in the room.
Representative Miller.
Here in the room.
Senator Mills.
Here in person. And members, thank you so much for, we have a very strong quorum this morning. And I'll turn it back over to Co-Chair Meredith.
Thank you.
Madam Secretary, could you please call the roll for the members of the Local Government Committee? If you are participating virtually, would you please notate whether you are participating in your Annex office or whether you're participating from your home district?
Okay, do you want me to call the Senate members again? Okay. Okay. Senator Alvarado.
Present in the room.
Senator Harper Angel. Senator McDaniel.
Present remotely in my district.
Thank you. Senator McDaniel.
Present in the room.
Senator McGarvey. Senator Nemes.
Present in the room.
Senator Schroeder.
Present remotely.
Thank you. Senator Southworth.
Here in the room.
Senator Storm.
Present in the room.
Senator Thayer.
Here in the room.
Senator Wheeler. Representative Bentley.
Present here in the room.
Representative.
In the district.
Who was that? Wheeler. Okay. Wheeler. Okay, thank you. Okay, Representative Bray.
Present in the room.
Representative Brown. Representative Dixon.
Present remotely from my district.
Thank you. Representative Donahue,
Yes, ma'am. Present.
Representative Fleming,
Present in the room.
Representative Frazier,
Present in the room.
Representative Huff.
Joining remotely.
Thank you. Representative Imes,
Present in the room.
Representative Johnson,
Present in the room.
Representative Koenig,
Present in the room.
Representative Lockett.
I'm present remotely.
Thank you. Representative Marzian.
Present in my district.
Thank you. Representative Meeks. Representative Miller.
Present in the room.
Representative Reed.
Present remotely.
Thank you. Representative Roberts.
Present remotely.
Thank you. Representative Thomas.
Present in the room.
Representative Meredith.
Present in the room.
Senator Mills.
Here in person.
We have a quorum as well, duly constituted to do business on this joint meeting. We have a very full agenda, and I know we're going to have a lot of questions throughout this process. I want to make sure that we adhere to a high level of decorum and respect for everyone that's going to be presenting today, and we deal with the big issues that we have in front of us. I think it's important that we understand the implications of the court ruling that happened a week or so ago, a week and a half ago, roughly, and some of the other implications of things that are going on with issues that are going on in our state and local government with regard to the corrections field as well. With that, want to introduce our first presenter of the day, Attorney General Daniel Cameron and his staff. If you all would please come forward. You all are going to be presenting with regard to the implications of the Supreme Court ruling in case that was before them. And if you all would just introduce yourself for the record, and then you may proceed with any testimony that you have on the subject. After you all are complete with the testimony, we'll open it up for questions of the members. If you'll get your microphone, Attorney General Cameron.
Is it working now? All right. Well, thank you, Chairman Meredith, and all those others on the committee. Good morning, and I'm certainly happy to give an update to this committee on the Supreme Court's decision less than 2 weeks ago in Cameron versus Bashir. The rule of law prevailed in that case, and the Supreme Court's decision is a win for legislative prerogatives and representative government. Just as a note, we continue to defend the laws passed by the General Assembly, as I've taken to committing to doing, and are currently engaged in roughly 40 such cases. But before we get into the Supreme Court's ruling, I imagine it's probably helpful to all of you all if we take a moment to reflect on how it actually got to the Supreme Court. The governor initiated Cameron v. Bashir back in February when he filed suit in Franklin Circuit Court seeking to invalidate Senate Bill 1, Senate Bill 2, and House Bill 1, which was the newly enacted legislation placing checks and balances on the governor's emergency powers. The governor asked the Franklin Circuit Court to enjoin the legislation, and the Circuit Court did so, first by entering a temporary restraining order, and later in March, a temporary injunction against those measures. After the General Assembly enacted House Joint Resolution 77, the Franklin Circuit Court expanded the temporary injunction to include that legislation as well. After the Franklin Circuit Court entered a temporary injunction, my office asked the Court of Appeals for relief from that injunction. Recognizing the great public importance of the case, the Court of Appeals recommended that the matter be transferred to the Supreme Court. The Supreme Court granted transfer of the case and heard oral argument on June 10th. On August 21st, the Supreme Court issued its decision holding that the Franklin Circuit Court, and I'm quoting directly, abused its discretion in issuing the temporary injunction. Therefore, it reversed the Franklin Circuit Court and remanded the case with instructions for the Circuit Court to dissolve that injunction. In reaching that conclusion, the Supreme Court evaluated the traditional factors that appellate courts look at when deciding whether to grant relief from a temporary injunction. First, the Supreme Court looked at whether any of the parties to the lawsuit would be irreparably harmed by a decision one way or the other. The Supreme Court found that this factor went against the governor. The governor claimed that he would suffer harm because the new legislation, if it went into effect, would reduce his power. The Supreme Court rejected that because the Constitution does not expressly give the governor any emergency powers, nor does he have any implied or inherent powers under the Constitution. Thus, his emergency powers are purely statutory, meaning he has no right to exercise emergency powers that have not been given to him by this esteemed body. This means that he is not injured in any legal sense when the General Assembly places limits or checks and balances on emergency powers. On the other hand, the Supreme Court found that the public would be injured if the challenge statutes did not go into effect. It is a well-established rule of law that the non-enforcement of a statute constitutes irreparable harm to the public and the government. The second factor the Supreme Court looked at was whether the governor's claim involved what we refer to as a substantial question on the merits. This factor essentially asks whether a claim has any legal merit to it. And the Supreme Court determined generally that the governor's claim had no legal merit. The Supreme Court first took up the governor's claim that the new legislation violates the separation of powers. Because the governor only has the emergency powers given to him by the General Assembly, the Supreme Court said it does not violate the separation of powers for the legislature to define and place limits on the governor's emergency powers. The Supreme Court next looked at the governor's claim that the new legislation infringes on his discretion to call special sessions by limiting declared emergencies to 30 days. In the governor's view, the 30-day limit will force him to call special sessions, thereby taking away his discretion. The Supreme Court expressed great skepticism about this claim, finding that the assertion that the governor would be forced to call a special session every 30 days is not credible. Nevertheless, the Supreme Court felt that it did not have enough information about this claim to opine on its merits, so the Supreme Court declined to make a definitive pronouncement concerning
shells if you want to make you one.
concerning the constitutionality of the 30-day limitation. Next, the Supreme Court evaluated the governor's claim that Senate Bill 1 violates his executive supremacy under Section 69 of the Constitution by requiring the Attorney General's consent to any suspension of statutes during emergencies. The Supreme Court rejected this claim out of hand, concluding that SB 1, Section 4 constitutes a valid exercise of the General Assembly's authority to suspend statutes. The Supreme Court then turned to the claim that the new legislation is arbitrary. The Supreme Court rejected that claim too, finding that the governor has no standing to make such a claim. Finally, the Supreme Court evaluated the claims that the legislation is unconstitutional, special, or local legislation. It also found those claims to be without merit. After evaluating the merits of the governor's claims, the final element of the Supreme Court's analysis involved balancing the equities and the public's interest. It had little trouble in determining that both the equities and the public's interest weighed in favor of adherence to the new legislation. According to the rules of civil procedure, the Supreme Court's decision will become final 21 days after it was issued. When that happens, the matter will officially be back in front of the Franklin Circuit Court with instructions for the injunction to be dissolved. In the meantime, the Circuit Court has instructed the parties to provide it with a status report no later than September 7, including any agreed order to dissolve the injunction. As a reminder, the issue in front of the Supreme Court was whether the Franklin Circuit Court's temporary injunction was proper. The decision is precedential, meaning that its reasoning is binding on lower courts. And on all but one claim, the Supreme Court's reasoning leaves no room to conclude anything else but that the statutes are constitutional. The only claim that the Supreme Court did not find to be meritless is the one about the 30-day limitation on emergencies. And far from finding that claim to have merit, the Supreme Court simply concluded that it needed more information before making a decision. On all other claims, the Supreme Court found that the governor's claims have no merit. Thus, while the Supreme Court did not officially declare the statutes constitutional, its reasoning will likely lead to that result, with the only potential exception being that 30-day limitation. And I am confident that provision will be upheld eventually, too, based on what the Supreme Court said in its ruling. The only way the governor could prevail on his other claims would be for the Supreme Court to reverse itself, and that would be exceptionally unusual, especially considering that its decision against the governor and affirming this body's authority was unanimous. So what does all this mean, and how does it inform what you all are doing here today and will be doing in the weeks and months ahead? It means that on or before September 13th, the Franklin Circuit Court's injunction will dissolve, rendering Senate Bill 1, Senate Bill 2, House Bill 1, and House Joint Resolution 77 enforceable. In the meantime and beyond, the Boone County Circuit Court's injunction precludes the governor from doing anything that would contravene or violate these laws. The Supreme Court spoke clearly in its opinion when it said, as we have noted time and again, so many times that we need not provide citation, the General Assembly establishes the public policy of the Commonwealth. With this language, the Supreme Court reaffirmed the legislature's unique ability, your unique ability to represent the diverse needs of the Commonwealth. I'm hopeful that the governor and the General Assembly can find consensus on what is needed to protect Kentuckians moving forward. And at this time, I'm happy to answer any questions that you might have. And I also want to make note that my Solicitor General, Chad Meredith, is here with me as well, and appreciate his service to the Commonwealth and appreciate you all. And I'm happy to answer, again, any questions that you might have. Thank you.
Thank you, Attorney General Cameron. Want to also just really quickly remind everyone that if you are participating virtually, to please mute your chat or your phone in the virtual function unless you're engaged in questioning. We want to thank you, Attorney General Cameron, for being here today, for presenting that very detailed version and very technical version of what occurred. Many of us on this committee are not attorneys, and so I think that was very helpful in how the process works moving forward and what the issues were before the court. Do I see questions from members of the committee? Senator Alvarado, I'm coming to you first.
Thank you, Mr. Chairman, and thank you, General. Appreciate you today. Appreciate you defending the actions really of the General Assembly. It's good to have someone in our corner in that role, and that's the role that it should be. I do have one question. I've read it. I'm no attorney, and I've read the opinion, obviously, and was pleased with the result. To give the legislature at least to recognize the role that we have also, that we're an equal in branch of government. But the concern I had was, I think, some of the comments that were made by the Supreme Court regarding the judge in Franklin County. And I think the term was that he was injecting his politics into his decision making, if I'm not mistaken. It's something along, I'm probably paraphrasing, but something along those lines. And so I'd like to get your opinion or your take, at least in that regard. I know that obviously there's a certain code of conduct from our judges, what they should be doing, how they should apply the law, that they shouldn't inject politics into their decision making when interpreting the law. What that means, I think there's some that would argue that that's become a common theme for that judge in particular. And there's concerns that, that's going to be continued going forward. What can be done in terms of that? Is there some kind of a review that gets done for judges who are injecting their politics into that? Maybe you can comment into that and provide a bit of guidance for members of the legislature in that regard.
Well, I appreciate the question, Senator Alvarado. What I will say is that I think it's my responsibility to make sure that I'm respectful for all of our judiciary, and will continue to be so. I vigorously disagree with decisions that are made, whether it be at the circuit court level, Court of Appeals, and even the Supreme Court. In fact, I don't come here today to toot the horn of our office. We lost in front of the state Supreme Court 7-0 last year. I vigorously disagree with that decision. I ultimately think it helped inform their decision-making as it related to this case and helped inform your decision-making when you came back into session earlier this year. But what I will say is that I think the Supreme Court, when they looked at this case in particular and the injunctions that had been rendered by the Circuit Court, the Franklin Circuit Court, what they look is whether there is a clear abuse of discretion. And they made it, I think, well known that there was a clear abuse of discretion in the determination that was made at the Franklin Circuit Court. And I'll point you to just one sentence in particular to say, in this instance, speaking about the injunction itself, we find that the trial courts, and this is the court's words, issuance of injunctive relief was unsupported by sound legal principles occasioned by an erroneous application of the law. And it's not uncommon for trial courts or even Court of Appeals, for that matter, to get things wrong or for reversals to occur. But I think that hopefully this will inform the Franklin Circuit Court as it proceeds on any cases related to this. I think the robust way in which our state Supreme Court made the point that you all hold the keys in terms of statutory authority and the ability to change the emergency powers is really important. And I think it's something that should empower you all as you consider your role in how we continue to fight this virus.
Representative Wheatley.
Thank you, Mr. Chair, and thank you, Attorney General. It's great to have you here, and I certainly agree with not agreeing with all the opinions that are issued by our courts, and having read opinions for a couple decades here, I wish I had more thoroughly gone through some of this opinion. But there's this this very general question, this very tension that exists related to special powers or the legislative having the power to call itself into session. That's something that was argued a lot on the floor of the House and the Senate. And I believe according to the opinion, your office states that it requires the legislature and the executive to work collaboratively. And that's a great thought. We hope that does happen and continues to happen. But what it does set up is that if the legislature and the executive branch works collaboratively, there has to be a result of that work. And that result is either some kind of amendment or change to the law. What has to happen as a result of the collaboration? How do we put that into effect?
As it relates to confronting COVID-19 or just?
Really, this could be for any issue that ever comes up that an emergency order, that emergency order expires or is ready to expire.
Yes, sir.
The collaborative work is done. What happens next to put the collaborative work into action?
Well,
and I'm sorry, I'll just go ahead and the only thing I see is the governor has to call a special session at that point. So I guess the question might be more succinctly put, by the legislative branch creating a law that something expires in 30 days, and the only way for it to continue is to have a special session upon the collaboration. Is that not the legislature calling itself into special session? And how do we answer that tension when it comes to the Supreme Court looking at it?
Well, to your question about the prerogative of the legislature to, place a limitation.
You're next.
Notably,
I can let your dad go if you want me to.
Notably, I think the Supreme Court made it clear that discretion resides with the legislature. It does not inherently reside with the governor. So I hope that you all can come to some agreement in terms of the governor's office about how ultimately you will handle additional measures to take in confronting COVID-19. But as to your specific question, whether you all decide after 30, or whether the governor decides, I hope you all can make a determination about that before. It is required some dire occurrence happens. So the 30 days, as I'm understanding that you all will ultimately be able to work with the governor and that he can call into session, that isn't a power that is given expressly to him. So I hope that you all are able to work together to do that.
Okay, thank
Yes.
you.
Just to clarify, Attorney General Crammond, that discretion to call the special session still lies with the governor. He
Right.
has the ability to call or not to call,
Right.
depending on how important of an emergency he sees it being.
Yeah, that is expressly an express power of the governor in the Constitution. So to your point about, he can call the special session, whatever. Again, I hope that you all, are able to have these conversations beforehand, and if it makes sense for him to call the special session to confront COVID-19 or whatever else that occurs.
Thank you. And if I can, Mr. Chair, the tension there obviously is that if there truly is an emergency, and there are many other kinds of emergencies, and I talk about this as a former fire chief, and having that ability to effectively put the emergency plan into place, and what it takes between the legislature and the executive branch to put a plan into place takes time, days, collaboration, hours, and we are in the middle of an emergency. And that emergency is that necessary, that needed, that there be a continuous plan. It seems like that is where the governor is compelled to call a special session, not by his own choice, but to really attack the plan.
Yeah, as I understand it, and correct me if I'm wrong, that 30 days can be extended as well. And so I think is out to 90 days. And so, again, that is a decision that you all are going to have to ultimately make in conjunction with the governor. But the power to call in the special session resides with him and is stated expressly in our Constitution.
Thank you, Mr. Chair.
Senator Nemes.
Thank you, Mr. Chairman, and thank you, Attorney General Cameron and Mr. Meredith, for your succinct and concise testimony. I have two questions. How long does the Franklin court have to lift the injunction? And does a judge have the right to make conditions when he is ordered to do something from the Supreme Court?
Well, I think the Supreme Court's decision is in force after 21 days, as I mentioned earlier. And I guess, is that September? No later than 13th. Yeah, November, no later than September 13th. As to your question about conditions, I think that would be in contravention of what the Supreme Court said. If your question is about putting conditions on the dissolution, is that, if I understand you correctly? So I don't see any room for him to place conditions on the dissolution. But again, I don't sit in the judge's seat and don't ultimately know how the Franklin Circuit Court will administer its dissolution. But as far as I read the court's opinion, there should be no conditions placed on it.
Thank you.
Yes, sir.
Representative Nemes.
Thank you, Mr. Chairman. I want to take this moment, if I might, to pause quick, and not too long, but to say this is a seminal moment in the relationship between the legislature and the governor, the executive branch. We've had a number of those throughout our history. This is a seminal moment. The governor was arguing that he alone got to declare when an emergency existed. He alone got to determine how to respond to that emergency, and that he alone got to determine how long his declared emergency existed. The Supreme Court said no. And they did it. And I'm an attorney. I used to be the chief of staff and the general counsel for the Kentucky Supreme Court. I've been in the room for a number of years listening to their deliberations. This is a cautious court. This was not, however, a tepid opinion. This was a very strong opinion. It almost gave it the back of the hand to the governor's arguments. It said, as we have mentioned time and again, so many times that we need not give a citation, the Assembly establishes the public policy of the Commonwealth of Kentucky. As General, you noted in your opening remarks, that's a strong statement. The opinion was replete with those types of statements. But I want to mention, I'm an attorney. I know not everybody on this panel are attorneys, and I want to highlight how strong this opinion is. This was done in the context of an injunction. And they, as the concurring opinion even said, they went further than they normally do in injunctions in addressing the actual merits. That's point number one. They also said that they addressed some of the governor's arguments, and he said, the governor was saying, we're irreparably harmed. And the Supreme Court went the other way. Mm-hmm. They said, no, you are irreparably harming the people. In a quote from page 17, the Supreme Court says, in fact, non-enforcement of a duly enacted statute, which is what the governor was doing, constitutes irreparable harm to the public and the government. It was the governor who was irreparably harming the people of Kentucky by his decisions. These are the words of the Kentucky Supreme Court. So it was in the context of an injunction. It was this stark language. And they had to find, remember, this is not the Supreme Court taking the case saying, which side do we believe? In order to rule for our side, the legislative side, that General, you so well supported through your Solicitor General, who did a spectacular job, as he always does in the Supreme Court. They had to find that the Franklin Circuit judge abused his discretion. That is a mighty, mighty big hurdle. The context of injunctions, they found that he abused his discretion, and they found that the governor was irreparably harming the people of Kentucky by his actions. I didn't see that in the news stories. It ought to be there. We've been saying it for a long time. Last point, and then my question. I want to address my friend Representative Wheatley's comment about do we take away the governor's right to call a special session? This was addressed. All you have to do is read the opinion. This was addressed on page 21, where the Supreme Court says, furthermore, the assertion that the governor would be forced to call a special session every 30 days is not credible. That's not credible. So that argument's been considered and unanimously been thrown to the side by the Kentucky Supreme Court. I will ask, I'm going to say, I thank the Supreme Court for being so strong, because finally, after 18 long months, as the governor admitted the next day in his press conference, it brought him, or the Monday, the opinion was on the Saturday, it brought him to the table, and he said, I'm going to finally give the legislators information that I've been able to see that they haven't, and I hope they make the right decision. And what it's done, to the Supreme Court's credit, is it's led the governor to the table to discuss these issues, and I'm informed that my leadership in the House has had good conversations with the governor and Senate leadership, and I'm happy about that, because we have a real situation we need to address. I'd like for you to comment, if you might, on the magnitude of the opinion and the moment that we're in, and how important the opinion was to decades and decades from now to establish the right of the legislature to be the policy-making body, and to keep the future governors from saying, I alone get to declare an emergency, I alone get to determine how to respond to the emergency, I alone get to determine how long my declared emergency exists. No one can check me. Can you comment on that? Thank you, Mr. Chairman.
Well, thank you, Representative Nemes, for those comments. And I think you said it said it very well, that the Supreme Court recognized that our framers of the Kentucky Constitution wanted to have a robust legislature, and that you all would be in the driver's seat as it relates to any changes to statutes. And that the other the other thing that is important to note is that they repeatedly expressed the point that the governor has no inherent or implied authority. The authority that he has is derived from statute, just as my authority as Attorney General, or as if Mike Harmon is State Auditor, or Ryan Quarles is our Ag Commissioner. That is derived from statute, and those powers and responsibilities are derived from you all. And I think the Supreme Court did a very well and thorough job of explaining that you all are important to the policy-making determinations, that what the governor has argued in case after case, and that his team has argued in case after case, is all policy, and that you all are the policymakers, and that you reflect the values of your constituencies, and therefore have done appropriately by making the changes that you did in the form of Senate Bill 1, House Joint Resolution 77, Senate Bill 2, and the others.
I think we've got a question from Leader Thayer, and before you ask your question, Leader Thayer, if there's anybody else, I have no one else on the list else that has a question, let us know quickly. Proceed, Leader Thayer.
Thank you, Mr. Chairman. General Cameron, General Meredith, it's great to see both of you before this committee. I feel like this day has been a long time coming. For the first time during my time in this body, we have an Attorney General willing to defend the actions of the General Assembly. And it's not about us per se as 138 individuals. It's about the people we represent. You know, the governor represents 4.5 million people. And so by very definition, as enshrined in our Constitution, the House and the Senate are closer to the people. House members under the current map represent about 45,000 people. Senators represent 115,000, give or take, plus or minus 5%. We are by very definition closer to the people. We are the people's branch of government. And I feel like if a couple of people could have just watched some of those old grammar rock videos that I watched as a kid, we could have saved ourselves a lot of trouble. And specifically, I refer to the ones called How a Bill Becomes a Law, and my favorite, No More Kings. Because that's how the governor's acted for the last month and a half. And we tried to engage with him. And finally, it took bills passed, vetoes overridden, court decisions, and this final decision that led us to this day. And to his credit, within 48 hours of the court decision being rendered, he did begin meetings with House and Senate leadership, and we are doing exactly what you said, collaborating. We are collaborating with the governor and his staff, leadership, committee chairs, bill sponsors, and we are working toward a special session that I believe the governor is likely to call very soon. What I like hearing the most is you say that there are no implied or inherent powers given to the governor by God, by the Constitution, by the courts. It is specifically the job of the General Assembly to decide what the job descriptions are for the executive branch. And while I have been here, we have changed the job description of the Commissioner of Agriculture. We have changed the job description of the Secretary of State. We have changed the job description of the Attorney General. We have changed the job description of the Lieutenant Governor. And now we have specifically enumerated the job of the governor. It's what all of us thought right from the start. And if we just could have had collaboration from the governor. One time he tried right before the second shutdown. To his credit, he tried, but I asked what took him so long. He got offended, and we never heard from him again until after the court decision recently. But I have a question about what occurred from the time the vetoes were overridden on Senate Bills 1 and 2, House Bill 1, and House Joint Resolution 77, and the court decision a few weeks ago. The governor did not follow the laws that had gone into effect. They all had emergency clauses. They went into effect. He sued. They were stayed. He did not follow those laws during that intervening time period. So my question to you, General, in your opinion, during that intervening time period, did the governor of the Commonwealth of Kentucky break the laws that were passed by the General Assembly as elected by the people of this Commonwealth during the last election cycle?
Well, I certainly think that there can be a debate about that. For instance, I think the governor, if you look at it from his perspective, says, I got a stay in Franklin Circuit Court. Meanwhile, folks in my perspective might think that what happened in Boone County, which I noted as well, enjoined the governor from doing anything that was inconsistent with the measures that you all passed. I think what ultimately the Supreme Court has done has made it very clear that you all, again, are in the driver's seat, that the governor cannot contravene the measures that you all have taken here. And, you know, at some point, I think there will have to be a conversation about in that intervening period about whether he was faithfully executing the laws of the Commonwealth of Kentucky. I know that has been maybe articulated in the Boone County case, but you know, I'm not going to say or cast judgment on the governor here without taking it under advisement. But it is an open question about what happened in that intervening period and whether the governor was faithfully executing the laws as you all prescribed them.
Thanks. I would assume there'll be a time and a place to get to the bottom of that. Thank you, Mr. Chairman, for indulgence, and I need to correct the record. Representative Koenig has reminded me that the videos I specifically referred to were part of the Schoolhouse Rock.
Schoolhouse Rock,
yes. Thank you.
Thank you all.
Two final questions on the radar for right now, and then I've got a very short follow-up question that's very technical in nature. Attorney General Cameron, Representative Smith, and if we could keep these last questions brief.
Keep them what?
Try to keep them brief.
I thought you said free. I was ready to say I'm not going to charge. General Cameron, I'll be real quick. I've been getting a lot of emails and correspondence on businesses letting employees go if they don't take the vaccine. I'm sure we're going to probably address that maybe in this special session if it's called. Have you given out any opinions on that, or has anybody wrote you to get an opinion from a business to I know we gave them some liability protection during the last session.
Yes, sir.
And it seems like all of a sudden it reverses and they start taking maybe advantage of that liability protection to say, now we can tell you if you don't get the vaccine, you can't come into our facility. And so being in business for 25 years myself in the private business, I find it disturbing maybe that the government would come and tell me how to run my private business. But then again, I would want to protect, as a representative, the employees that are being told they have to go to the house because they haven't had the vaccine. So my question to you is, do you have an opinion on it, or have you had researchers to look at it? I'm sure I'm not the only one that's heard this. I'm sure you've maybe had a few emails yourself on it. But could you just maybe, I don't know if you're allowed to elaborate on things that you don't have an opinion written on yet, but
Attorney General.
But that is a lot of the emails that I'm getting. So if you could touch on it.
You may answer that question if you will, Attorney General Cameron. I will just say I think that's a matter of public policy that has not been addressed at this point, and if he does not have an opinion formally.
Yeah, so I don't think we've received anything in office as it relates to that. And obviously you hear about employers and some requirement of vaccines. You know, I think a focus for our office, and again, just something that as I think through sort of constitutional implications, is, you know, does that, you know, mandate have exceptions for religious or any other faith component or other exceptions that are in place, but without looking specifically at of an actual opinion request that's come into our office or a specific facts related to a vaccine requirement in a private business, I wouldn't be able to comment further than that, sir.
My last question dropped off. Attorney General Cameron, my real brief technical question. Yes, with regard to the 30 days, I think there is something in that 39A statute that deals with a local control component. Could you address that just very quickly?
Yeah, and so that's what I was referring to with Representative Wheatley, is that there is a mechanism by which there can be an extension of the 30-day period that at the local level for up to 90 days, I believe. Yeah, up to 90 days. So I don't, if we can obviously confer about that more, but again, the ability to enter into a special session is the governor's. He loses no discretion to do that. That is a constitutionally expressed ability that he has. But it's up to you all in terms of how you collaborate about how to move forward on that. And, I don't have an opinion on your legislative prerogative on that front, so.
I think specifically the citation in the law states that a local legislative body or local executive within their jurisdiction can request that extension, if I read that correctly.
That's correct.
Attorney General Cameron, thank you all for being here and your presentation. It has been very, very informative. We appreciate your all's help.
Yes, sir. Thank you. Thank you all. I appreciate it.
We're going to deviate a little bit from how the agenda is shown before you, and the next group we're going to bring up is the Kentucky Jailers Association to talk about COVID-19 in jails and their response to COVID-19. Jailer Daly, if you would approach, introduce yourself for the record, and then you may proceed with your presentation.
Thank you, sir. James A. Daly, much prefer Jim. I am currently the president of the Kentucky Jailers Association and the Campbell County jailer. Been involved with the jail up there for, about 20 years on and off. Served as the county attorney for a while, started my career with state police. So I haven't really been able to keep a job, but they keep bringing me back. I am here today to talk to you about, look at my notes, the costs and expenses of COVID and how it's affected local detention facilities. And
Jim, could you pull that mic just a little closer to you?
just get ready to move it away. Is that better?
Yes.
All right. So beginning in March of 2020, jails really started having a lot of problems and a lot of issues that required us to make significant changes to our operations at the local detention facility. Of course, with those changes came substantial cost, which is, I guess, why we're here today, to make sure that that's understood from at least the jail's perspective. Pardon me, it's the first time I've been back here for many years. So a couple of things that hit us pretty hard early on were the emergency orders that came out from both the executive branch and the Supreme Court. So the issue, I guess, that I need to highlight the most are the intangible costs of those types of things suffered by jails and counties. And just, I guess, as a sidelight for me, one of the big things that I preach from a local level up home, and I don't know how many of you are intimately familiar with your jails. My jail has about a $17 million budget this year. I am the largest employer in our county for any governmental entity. So it is, for anybody that has a full-service jail, it's a big deal. It's very, very expensive, and our county fiscal courts are tasked with that by statute, and they have very little opportunity for any relief for those costs that are borne by the local fiscal courts. To drop back a little bit, when I talk about cost, and this one hits pretty close to home, at Campbell County, we lost 2 souls, so that was the biggest cost. I lost a 20-plus year sergeant, and I lost a 2 or 3 year deputy to COVID. So that was our largest cost, and I know jails throughout the state have suffered that same, but that was a big deal at Campbell County. Another issue of consequence we have to recognize, and this one I think escapes a lot of people. As elected jailer, you'd think I would have some control over the jail, right? Well, we don't. We don't control who comes in. We don't control how long they're there. We don't control when they get out. I don't control my own budget. I am extremely fortunate in Campbell County because I have a wonderful fiscal court and a wonderful judge exec. But again, all of that's set by statute. So if they don't give it to me, I don't get it. And that's true for every jailer in the state, but particularly for every full service jailer. And it becomes an item of contention out there for a lot of detention facilities. Again, as a result of the lack of control that we have, I will tell you that many jails, and actually most jails, aren't equipped to deal with quarantine or other issues that are a result of COVID. My jail, I have, of course, we went forever and didn't have any issues. Then all of a sudden, I had 200 people with COVID. Within a month, I was COVID free. Today, I have about 18 people in my jail that are COVID positive. I am without 3 deputies again because they're COVID positive. And then I have a couple of people out because family members are COVID positive. So that these intangible costs that you don't see from the outside are always heavily personnel related. And it's very difficult to hire people to come into a jail anyway, but you add COVID to that and it's neon impossible. I have a suggested capacity for deputies of about 85. I am 50 down. So I'm running a potential 656 bed facility. I've got about 450 today, with 50% of my capacity gone. It's dangerous and difficult. The issues I was going to talk about, most jails, and again, I'm very fortunate because I have 18 isolation cells. I have dorms that will hold up to 64 people each. That's a suggested capacity if you talk to corrections about it. But then I have a multitude of other cells of various sizes, anywhere from 5 up to 25 or 30. I'm lucky. Most jails don't have that opportunity or don't have those. Another big issue, of course, and especially with the number of people I have missing, is overtime. And again, with COVID, overtime has been crazy. As I said a minute ago, staff shortages are always bad. Right now, they're horrible. And again, I'm very fortunate in Campbell County, and I just brought some stats, but since COVID started, and I'll just pick a couple out here, but in July of 20, my monthly overtime bill was $80,000, which is excessive. But when I'm that short on staff, my fiscal court has to step up and pump that money into the jail. This year, again, and I'll just stick with July, my overtime budget was $30,000, and then totals for 20, I spent $698,543 just in overtime. So far for 21, $601,312 just in overtime. That's on top of my actual personnel expenses. The staff shortages, again, when you try to hire people, and it's the good old days of government work where you had a good retirement, you didn't get paid as much. We're fighting against all of that. But now on top of all that for jails, we have volumes of overtime that we have to fill. I have people quitting because they can't take a vacation. They haven't been able to have a vacation for over 2 years now. They have lost days off. We have on-call people every week that we have to call in. And of course, that gets worse as time goes on. And then, if you think about it realistically, add on top of that these folks are working inside of a closed environment. The air circulation is constant within that environment, and they're working with what we now have been told is an airborne disease. So they not only have to worry about their own health, but they have to worry about what they get to take home to their families, their kids, their people that live with them or that they live with that may be compromised. Pardon me. Another area that we have to deal with are courts and court-related issues. Transports, I don't know many of you are involved with the fiscal courts, but transports between jails for the last 18 or 19 months have been basically shut down. Now, we recently started doing them a little bit ago, but now with COVID making the comeback that it is, and we did this by agreement with jailers, right? So we're probably looking at having to shut these down again because all we're doing, if we continue, and there are a few folks out there that will send you somebody that has COVID and they won't even tell you about it. Hopefully, and I know for a fact that it's only a couple, but it does happen and we have to deal with it. The other thing we had to do was we had to implement and we had to pay for virtual courts. And that's a big deal because if you don't have virtual courts, then we have to transport because some judges want to have that body in front of them, particularly for pleas, but they also want to have them before them so they can see them if they're having problems with their attorney, having problems with discovery, I mean, any myriad of issues that you can think of involved with the court system. And then we have to set up and we have to maintain online visits for attorneys, particularly public defenders. But we have to do this not only in my county, but because of the number of state inmates that I hold, I have to do that for counties throughout the entire Commonwealth. So it's a big deal and it's expensive. I hired my own IT person to deal just with that issue. So that was a $60,000 hit, plus benefits, plus the actual equipment. It was a big deal for us in Campbell County. But, I felt like it was I felt like it was our facility's duty because I have people from all over the state. Again, over the year with courts, we had to institute new policies. Again, virtual court, COVID testing, we're doing that. We have to do that for courts all over the state, and particularly like this morning, federal courts want the responses on Wednesday. Well, I'm driving down here this morning at 7:30 and they're already calling me. Why don't we have them yet? Well, I have 400 inmates to test. We'll get them as quickly as we can. Dealing with courts is a whole lot of fun from time to time. But limiting visitation, and this is an interesting one because we receive a call from corrections that say you need to limit visitations. You need to stop people coming in and out of your jails. And then they turn around as part of our inspections and say, well, you don't allow visitation. What's going on? And they have written a couple of jails up for it. So damned if you do and damned if you don't. We had to stop faith-based services, which is a big deal, constitutionally required. Substance abuse treatment and our moral recognition therapy. Those are programs that the state and that local jails really want to have, really need to have, right? These are the folks in our society that want to talk to people from their churches. We can't let them in, especially at the height of COVID. I just talked about starting it again, and I had to shut it down again because of the problems that we're having now with COVID and the new variant. All of these changes were made with no extra funding from the Commonwealth. Our revenue streams during the pandemic have taken a drastic hit, leaving our budgets pretty meek. And again, I've got, and I make copies of this stuff for you guys if you want it afterwards. But, with overtime, another thing that I did was I paid, and thank God for the county police department, I paid them over $10,000 a month, several months, $8,000 and $5,000 and $6,000 a month for them to supply people to work in my jail. Getting county policemen to work in a jail is a feat in and of itself, but we did get it done. But other things that we took and took hits on, my overtime, my prisoner count for 21, I lost $1.6 million on revenue that I would have gotten from state inmates. And I've got that broken down here by months if anybody has any interest. I can share that with you as well. Again, I'll get to, we had some good news. Spent some time late at night on telephone with Senator McDaniel and some folks from the legislature and had House Bill 556 passed. That was supposed to allow us and our fiscal courts, and that's the thing, never spend money until it's in your pocket. But we were told we were getting an extra $2 a day per diem, the duration of COVID, and then remarkably, that money disappeared. The bill was further going to incentivize jails by rewarding who would offer programs to rehabilitate inmates. That is still in the process, but it's a process. The truth is, not a single county facility has received any of the funding outlined in House Bill 556, and the Department of Corrections has recently communicated with us that expenses are not recoverable without a line itemization of these expenses. So mean, think about that from a realistic standpoint. All of the things that I have mentioned are things that we deal with on a daily basis, whether it's overtime, people missing. All of that has been substantially exacerbated, but I didn't start tracking that. And a lot of those things, there's no way for a jail, and I've got great staff. My fiscal court takes care of a lot of the things that have to do with my funding, so it'd be easier for me than a lot of people. But you take these smaller jails that are costing your county a ton of money, they don't have the ability to do that. They don't have the people to do that. It's a very expensive process, and you're going to have to go back for 18 months or, depending on when this all stops, a couple of years. They're just quite simply not going to be able to provide numbers to substantiate all these expenditures.
Jim, I don't want to cut you off, but I know we've got several questions. If you don't mind to move into the question phase, we've still got another presentation with corrections, and I don't want to cut it short as well. But I appreciate your information, certainly, and if you're okay, we'll open up to questions.
Absolutely.
We're going to start with Representative Lockett. I think you're virtually on, Representative Lockett.
Yes. Yes, thank you, Mr. Chairman. I just have a couple questions, really briefly. Can you kind of describe, you talked a lot about safety in your jail. Can you describe what type of policies are in place to provide any type of PPE to guards or other jail staff?
Yes, sir. And keep in mind, too, that I can only speak to what happens at the Campbell County Detention Center. Each jailer has the ability to make those rules himself, although in discussions I know a lot of them are following the same suit. But at Campbell County, particularly during the height of COVID and recently, we've gone to a mask mandate. I believe it works, especially in a closed environment where you have people on top of each other 24/7. So we've gone to a mask. We've also gone to the temperature taking. So if people come in, and again, I've heard good and bad, but you know what? It's a safety precaution. It doesn't cost me but buying a half a dozen or so thermometers. So we're taking people's temperatures coming in and coming out. The other things that we have done is we've stopped in-person visitation. We've stopped attorneys from coming into the jail visiting their clients. We've set it up where they can do it online. We've set it up hopefully where they have the confidentiality they need. We've taken steps to be able to bring in materials or to allow them to bring in materials for us to give their clients so they can read them. I mean, we have jumped through a multitude of hoops to hopefully protect their constitutional rights while they're in our facility.
Thank you. Just to follow up to that as well, do you have any idea what percentage of guards or jail staff have been vaccinated?
Again, I can only speak to my own facility, and we are something over the 50% mark, and we're continuing to offer them every day. Along those same lines, I will throw out that we've had over 200 of our inmates, which I'm very proud of because they think it's a conspiracy, right, to track them. But we've had over 200 of our inmates, and a lot of those state inmates get the vaccination.
And do you happen to know what either percentage or the number of staff and or the inmates that have been diagnosed with COVID and recovered?
I don't even know that from my own facility. I can tell you sitting here that I know I've had at least a dozen that have had COVID and have recovered. And again, I had 2 that died. But for the other facilities, I apologize. I don't have that information and didn't have the opportunity before this to get it.
Okay. Thank you, Mr. Chairman.
Representative Moser, I think you're on virtually as well. You got a question for us?
Yes, thank you, Mr. Chairman. And it's good to see you, Jim.
Yes,
thanks for coming to present. That was a very thorough presentation, and I really feel for you, knowing how much you care about your jail and Campbell County. So, it sounds like there's a lot of work that we can do to readdress some of those funding issues. But my question really revolves around the DOC contract. to provide beds for substance use disorder with various vendors around the state. Do you know how that's being utilized? Because it's my understanding that many of those beds are going unused.
And I don't know the answer to that, and I know you and I have had that conversation in the past. I do my own program. I don't do the state's program. Difference of opinion on effectiveness. So I don't really track that and have not had any calls or questions from other jailers on that issue.
Okay. All right. I think that would help alleviate some of the overcrowding issues that you're experiencing and other jails, especially in the population of inmates who really could benefit from substance use disorder treatment. So I think that we ought to look into that and see if we can get you some help in that area.
I'm but a phone call away, as you know.
I know. Thanks.
Senator McDaniel.
Thank you, Mr. Chairman. Jailer Daly, thank you for coming today. And we did speak at the end of last session. I want to touch on a few things in particular. As you know, Representative Mosier, Representative Nemes, those folks are better on the policy side, but I tend to be the person who exists where finance and policy have to intersect. That being said, you brought up the loss of state inmates and the 1.35 million, I think you said it was just to Campbell, which necessarily means because we didn't reduce the current year appropriations in accordance with the reduction in inmate. So there is a savings because that's not inmates that the state took back in. Those are inmates that were released, correct?
A lot of those were
governors.
released, Senator. Now, I shipped out because I lack staffing. So a couple of months ago, I did ship out about 85, but that was this year. So those numbers I gave you were from my last year's budget. That's all savings to the state somewhere.
Somewhere. Thank you. Secondly, you mentioned about the cost of transporting prisoners. We also allocated money last year through AOC's budget designed to give 100% coverage for video conferencing with the court system, and necessarily the jails should have received money to begin to set that up. How is that progressing?
I haven't seen a dime.
You've not? Okay. And then lastly, I know that there's some controversy that you addressed surrounding the ARPA funds that were allocated for COVID. And I want you, much like this body passed Senate Bill 5 for businesses and organizations that were doing their best to cope with an ever-changing set of regulations and guidances and things, I want to walk through a scenario with you and feel free to correct my logic in this, but you had 2 deputies, as you testified, pass to COVID. I'm sure you had deputies contracted because they're like every other organization and employer in the world had this happening. Those employees, basically, they're able to give you, if you're lucky, 2 or 3 hours worth of notice. Then all of a sudden, you've got a 14-day hole to fill. You don't have enough deputies as it stands right now anyway. And even if you were 100% staffed, what that necessarily means is at a minimum, you're immediately bringing somebody in on overtime. And you're just bringing them in and you pay them on overtime, and it goes to the cost code of overtime for your jail. You didn't bother to say at that point in time, because there was no real reason, hey, by the way, we're working this overtime because of COVID versus, because Jim sprained an ankle playing basketball last night and he can't walk now. It just became overtime and naturally just got absorbed into the cost of doing business at a jail. Is that a fairly accurate statement to make?
That's an absolutely accurate statement to make.
And so I think what we need to realize is the intent of this body when we appropriated those monies. It was to defray the cost. In fact, we didn't think that it would be enough to actually cover the cost. It was just to defray. And so I would say to our friends in Budget and Corrections, we don't write budgets so that you can decide later that folks that were on the front lines deserve less. And I would hope that they would begin to reconsider their position before we as appropriators need to reconsider how we view them. Thank you.
Representative Frazier.
Thank you, Mr. Daly, for sharing your experiences with you at your jail. My question is in regards to state inmates that are housed in the county jail. You alluded to this a little bit, but do you have an approximate vaccine rate of those? And then also a second part of your question is what you're hearing from other members in your association. Vaccine hesitancy, that type of thing.
Yes, ma'am. Again, I really can't speak to all of the other jails except for what we have conversations about off the cuff. And some of them were late in even having the ability to get the vaccinations, so they had a slow start. We were fortunate, again, in Northern Kentucky, our health department jumped on board very quickly. So again, we're at around 50% of our current population. Now, keep in mind, I've also inoculated many that have been released or gone back out into the community, and that's why we used the one shot. I apologize, I can't remember the name of it, but we used the one shot at our facility, so if they did get out, they would be covered. But that 50% that we have now, again, there are those that have been released that have also been inoculated, if that answers your question.
It does. Thank you very much.
Yes, ma'am.
Representative Tate.
Thank you, Chair Meredith and Mr. Daly, for your presentation. So in your presentation, you talked about quarantine.
Yes, ma'am.
So can you describe to communicate what quarantine policies have been implemented to you? And then also, based upon your experiences, if you could make a decision on a local level, whether those quarantine policies would be different.
So the quarantine, there is no quarantine policy across the state, if that's what you're asking. Again, each jailer is on their own, and it is at best described as a game of Monopoly. What we do is we quarantine them coming in for a period generally of 7 days now, although we're going to go back to 10 probably this week because of the influx of new cases. But we quarantine them initially when they come in, and then if they have any signs or symptoms, then they go into a separate quarantine area within my facility. And then they stay there for another 10 or 15 days until we feel like that period of time has run, that they could pass it on or that they're well. And again, that's all a guessing game because nobody really knows.
Yep.
Yes, ma'am.
I have a follow-up for that. So I appreciate you talk specifically about your inmates. Can you talk about from your staff's perspective as well?
For
quarantine, what your is there any policy that's been established for your staff, for your deputies, and what if that's again on a local level if you're making that decision?
It's absolutely on a local level. Okay. And at Campbell County, what we've done, if they come in and they have symptoms, we were putting them off of work. And they were off 10 to 14 days or until they had been symptom-free for 10 days. And those are, again, kind of arbitrary numbers, but they are what our local guidelines from our health department advised us to do. So we followed that. And then, of course, if they were sick, whether it was known at that time to be COVID or not, they were immediately sent home. And now, again, if they are inoculated and they are symptomatic but not sick, we are allowing them to work with an N95, which is, I guess, supposed to be the best mask that you can get for it. But that's a recent change, and we've done that because, again, the guidelines have told us that they should be safe with those masks. And what we're doing then is we're putting, to the best of our ability, again, that's why it's a monopoly game. It's really mind-bending. But what we're trying to do is have those that are positive from deputy standpoint, we're putting with positive inmates. Or if the deputy is showing symptoms, or showing symptoms is not right, if they're inoculated and they've been exposed, then we're allowing them to work with exposed inmates as best we can. The truth is that we don't have enough people to limit it completely, but they're all masked up, and we've given them what are the guidelines on the stay 5 feet away as best you can, et cetera, et cetera, et cetera.
Great.
I hope that answers.
It did. Thank you very much. Thank
Yes,
you.
ma'am.
Thank you.
Representative Stevenson.
I have a question. When you have a new inmate, are they isolated for 14 days before they go to the general population?
Right now, we're doing 7,
7.
unless they're symptomatic.
And the other part of the question is, I'm trying to understand, if we've cut most visits, how are the inmates transmitting the virus to one another? How are they getting it if they are a captured audience, if you will? Like, how is it getting in?
If I knew the answer to that question, not to be a smart aleck, I'd be a billionaire.
Yeah.
I really don't know.
Yeah.
The only thing that we could figure out is that maybe staff had come in, or an inmate came in that had not mentioned or told us that they had been exposed, and they were asymptomatic. It's the only thing we could figure.
And then the last part of that is, what do we do to protect the inmates? I've heard what we're doing to make sure the guards are safe, but do we have any protocols in place to protect the inmates from COVID?
Yes, ma'am. All of our inmates have masks, and they're given new masks from time to time. And we don't make them wear them, if they're in a cell with 10 other people, we don't make them wear inside the cell. We kind of thought that would be ridiculous. But anytime they're outside of that cell, they have to wear their mask. And then if we know they're COVID positive, we're putting all COVID positives together in a cell. If they have been exposed, we're trying to keep those that have been exposed together. And then, again, we're really lucky in Campbell County, but I have 24/7 medical. So if they need treatment, we're trying to do our very best to make sure that they get treatment.
Thank you.
Yes,
Have
ma'am.
you had any inmates die from COVID?
We had one that did. Yes, ma'am.
Thank you very much.
Yes, ma'am.
My final question is coming from Representative Koenig, unless there's anybody else that has one. Representative Koenig, go ahead, and if there's anybody else, let me know.
Thank you, Mr. Chairman. Quick question, quick comment. Jailer Daly, thanks for coming down here from Northern Kentucky.
Yes, sir.
You talked about the mixed messages from Department of Corrections about visitation.
Yes, sir.
And I'm sure Corrections is listening, and I hope they'll address this when they get the opportunity to speak. But what is your understanding as to the visitation policy? Do we know if any counties are doing visitation, and if so, how many?
I don't know the answer to the last question.
Okay.
We're all doing visitation in different forms. But I think the issue was that they had stopped in-person visits. So, and again, I apologize, that's all a matter of definition, because we don't have any in-person visitation at Campbell County. It's all online, or it's by camera from our visitation area in the front of the jail with the folks in their cell. But a lot of jails had, because they personnel, because of the facility, the size. None of this is a simple answer, and I apologize, because every facility is different.
Mm-hmm.
And again, Kenton County's got a beautiful facility. They have the ability to keep and move people around, right? Although they have a lot of large areas, but they still can concentrate people, and they have a nice visitation area up front. A lot of jails don't have that. A lot of jails, it's still in-person visit, and you quite simply can't do that when you have this kind of an issue going on. So it's impossible when you're restricted. And again, I don't mean to pick on corrections, because they're, I get along with them very well, I hope. I think I do, and they work well with me. But it's, they're required to inspect us, and if you don't provide some form of visitation, they're required to write you up. Now you're going to get a slap on the wrist, and they understand, but it's still very difficult when a jailer looks at me and said, I'm just doing what they told me, and then they come in and they write me up. So I give them my thoughts on how to respond appropriately.
Right. Well, I would ask when they get up here to clarify that for everybody in their presentation before us, and let me just state that having been on fiscal court a long time ago now, I know what the cost is, and the state has been skating by with not giving anyone raises, whether it's employees or jails. But it's time for us to seriously consider increasing the per diem on a permanent basis, not just COVID related. Thank you, Mr. Chairman.
Yes.
Final question for this part of the presentation, Representative Lewis.
Thank you, Mr. Chairman. Mr. Chairman, me and you have had these discussions and all you did this past year, and Mr. Daly, I try to have a very good relationship with my jailers. Linda Smallwood there in Clay County, Jamie Mosley and Laurel, and Danny Clark and Leslie, and all of them are struggling right now, and everything that you all have gone through this past year, whether it be PPE requirements, new equipment, visitation policy, you name it. And I was reading just across other states what different organizations are doing and facilities, and I see a lot on ventilation systems, and obviously there are large capital requirements with that, and I echo Chairman McDaniel's concerns on, we're trying to defray the expenses that you all have. But are you seeing anything across other states or within Kentucky and members of your association on whether it be ventilation systems or changes in policy that we could adopt here in Kentucky?
Well, of course, all jails are supposed to have ventilation systems set up, especially fire-related, those kinds of things. So those things help. All jails are supposed to have, all full-service jails are supposed to have those systems, right? But what I would tell you, and I get all kind of materials from the American jailers and the Kentucky jailers by discussion. But we're all nationwide having the same problems because that ventilation system basically just circulates air within the jail. Now, I have some isolation cells in medical that are negative air, but my whole facility is not. So it's that's what I was talking about before, where the deputies are inside of that jail, and that they're breathing that same air that's circulated over and over and over. And again, it's just, to me, relatively recent that, and I still don't know if it's correct or not, that it's airborne, that, it's always been, you have to be within, a sneeze, that's the 5 foot, if they sneeze or spit or some other way. And in our business, if you have to fight somebody that's COVID positive or they spit on you, throw feces on you, all of those wonderful things that go on in a jail are the things that we have to deal with. The air really is, maybe it should be, I guess, but it's not high on my list of priorities. It's protecting them from that direct personal contact that we know they can transmit it through.
Sure. Thank you, sir. Thank you,
Yes,
Mr.
sir.
Chairman.
Jim, thank you for your presentation and for coming down from Northern Kentucky today.
Thank you very much for having me. I always like the opportunity to get some help. Thank you, sir.
Final part of today's meeting will be the Department of Corrections. I think we have Commissioner Cookie Cruz and General Counsel Robin Bender both on virtually. If you all would please introduce yourselves for the record, and then you may proceed with your comments.
Okay. I'm Cookie Cruz. I'm the Commissioner for the Department of Corrections.
And I'm Robin Bender. I'm the General Counsel for the Justice and Public Safety Cabinet.
So I just kind of want to go into the Department of Corrections story of how we've handled COVID, where we were last year as opposed to where we're at this year. In March of 2020, Green River Correctional Complex had their first COVID positive staff. In April of last year, we had our first positive inmate. It was a time where none of us really knew how to handle, didn't have the information of how to handle COVID. We didn't have PPEs, we didn't have testing, we didn't have vaccinations. None of this stuff was at our disposal. Later, another month down the road, we were able to get testing, mass tests, all of Green River. We started moving and isolating people, putting positives with positives, negatives with negatives, exposed with exposed, and we moved our vulnerable population into our gym so that we could move these people back into the Oldham County area. We had medical people who were going door to door. When you look at Green River, each inmate had a roommate. And so sometimes the roommate would test positive and the other roommate would not. So we were moving people around every 7 days. We had nurses go and take temperature checks and checking on inmates because then they didn't want to know that they were positive, and we had to respond to emergencies. It was a matter of making sure that the local ambulance was on our side of the town in case we had to take people out to the hospital. We were running that ambulance consistently with our inmates going out to the hospital. It was a hard time on our staff. Once we got them up and running, KCIW was hit in June. They were hit again in the fall of last year. KSR went positive in July of last year. A small portion of North Point Training Center went positive in July also. Then in October, Little Sandy Correctional Complex and Bell County Forestry Camp had positives. November, Lee Adjustment Center and Blackburn Correctional Complex went positive. And then in December, Rotor Correctional Complex, Eastern Kentucky Correctional Complex, North Point was hit a second time, and so was KSR a second time with COVID. In January, Ross Cash, which is the women's division of Western Kentucky Correctional Complex, went positive along with Luther Luckett Correctional Complex and Southeast State. In March, KSP, and in April, Western Kentucky Correctional Complex had positives. It has been extremely hard on our staff and the inmates. We lost 48 inmates to COVID last year, and we lost 5 staff members to COVID. I have been in the system for 37 years. I started at the women's prison in 1984. It's hard to see the inmates that I grew up in the system with pass on, and the staff members that you work side by side pass on. It's been extremely hard for our staff. Our vaccination rate going into the pandemic was 20.60. Coming out of the pandemic, our vacancy rate is 50.36. It is hard to run a prison with that much vacancy rate. Some of the staff through the height of COVID didn't want to take it home to their family. They left. Some came back after that institution got up and running. When vaccines came into play, we, I think it was right around April, we start vaccinating anybody who was vulnerable, 80 years old and down to 60. Then we were a provider, and we can vaccinate any of our inmates or staff at any time if they want to. What I'm most proud about is that today our inmate population vaccination rate is at 8302. Our institutions vary, and this is kind of old data by a couple of weeks, and I can tell you that when you're talking about giving rates on tomorrow, our vaccination rate for inmates may be up and our vaccination rate for staff may be up, because we have this big wheel in and out, both with staff and both with inmates. But the institutions specifically, it can range from an institution 35% to 75%. So all of them, depending on where the institution is laid at, is what their vaccination rate will be. I think the things that that worked for us, and I can only speak for the Department of Corrections, is that we currently test staff twice a week if you're unvaccinated. It usually occurs the day before your off day and then the day you come back from your off days. We have staff that are working 7 days a week because we don't have enough staff to go around. They're working continuously overtime. They're exhausted. But I'm going to tell you, this is the best group of people that I can ever work with because they're pretty dedicated to what they do. Through the height of COVID, I had people who said, well, you know, I tested positive, but I'm be willing to come in and work. And, you know, my response is you've got to take care of yourself and you've got to take care of your family. So you need this time to rest. We have managed through COVID, and the best thing to ever happen to us is that we have the capability of testing, vaccination, and mask wearing. We continue to do mask wearing. We continue to do testing. Inmates that are unvaccinated are tested 10% every week, just to make sure by the end of the month we have tested all of our unvaccinated people. During this wave of COVID, I want to do a little comparison to show you what I mean about why this has worked for us. When Western went positive in April, they had 358 positive male inmates during this time. Western had a breakout in August. They have 79 inmates that are currently on their general population yard that are not vaccinated. They have 62 people right now that are positive with COVID. Now, in April, with no vaccine available every day, just about, it seems like we were taking an inmate out to the hospital. During this breakout, with the tools that we have in hand, 62 people as of today, and we still have some testing going on, 62 are positive, but only 2 inmates during this period of time since August the 14th has had a fever for 24 hours, and that's it. 14 of them have recovered already, and the rest of them by the 10th of September will be fully recovered. Now, we do testing if somebody is coming into our system in the assessment centers that we have across the state. We rapid test you as soon as you come off the bus. 7 days later, we test you again, and 7 days later, we test you again before we put you in general population. We want to make absolutely sure that our population, when you're going amongst everybody else, that you, to our best ability, do not have COVID. I've lost already one staff member who I worked with for years to COVID this time around. So it works for us. So I'll entertain any questions. I know that's a fast overview, but I'll entertain any questions that you may have.
We do have several questions, Commissioner Cruz. We're going to start with Representative Decker.
Thank you, Mr. Chairman, and thank you for that report. I was really sad to hear and could tell that you were sad to give the report on how many inmates have died and how many of your staff has died, and I appreciate
Representative
that.
Decker, I'm not sure your microphone's on. I bet she can't hear you.
It's on, but it must not be close enough. I wanted to thank you for your testimony, and I was commenting on how sad I was to hear about the deaths of your staff and your inmates, and I could tell it was hard for you to give, and my condolences. I wondered if you could tell us, you've given us some numbers since August, but overall, how many inmates have tested positive for COVID and recovered?
I don't have all of that in front of me, but I'll be certainly to get it back to you. And I'll break it down by institutions.
Thank you. And just a follow-up question.
Go ahead, Representative Decker.
I've heard several, you've given several different reports about procedures you have, but do you have an overall procedure for differences in how you treat people who have had COVID, had the vaccine, or have not had COVID or the vaccine? Do you have protocols in place in general for the different treatment?
Can you say that one more time?
Yes. Do you have protocols for differentiating the treatment or the movement? You've mentioned testing. Do you have different protocols for your inmates who have had COVID, have had the vaccine, or who have had neither?
What we look at is vaccinated and unvaccinated, and we do it on a case by case of treatment.
Okay. Thank you.
Representative Heverin.
Thank you, Chair. Thank you, Commissioner, for being here today. I greatly appreciate it. My question actually involves Pewee Valley. And so I was curious of what specific steps are being taken to mitigate the spread of the virus at Pewee Valley. And then do you all have any idea of when that facility will have power restored?
Their power, I'll do the second one first. Their power was restored last night. They're on generators, I want to say. The power structure hasn't been fixed, but they're on a fully powered by generators. We got some brought in from the outside to be able to hook up all the 2 living units that it really affected. And what was the first question?
Yes, thank you for the answer on the second one. What specific steps are being taken to mitigate the spread of the virus at Pewee Valley?
Well, we have the same thing across all of 14 institutions, is that we're masking, we're testing, and we're vaccinating.
Thank you.
Representative DJ Johnson.
Thank you, Mr. Chairman. And again, I want to say my thanks for the presentation and also your passion as you've been talking with us. I just want to, in case Representative Lockett doesn't make it through the queue again, I would like to ask again the questions about if you have a feel for the percentage of staff and guards that have been vaccinated, and also in combination with that, the percentage of staff and guards that have had COVID and have recovered, because when you take those two statistics together, I think you get a clearer picture of where we stand as far as immunity goes.
I can speak generally, and I'll have to get the second part for you. It depends on which community that they work in. So if you were looking at the eastern part of the state, the vaccination rate would be low. If you look at the Oldham County area, which has 3 prisons in it, most of them are running around 50 to 70%. Like the reformatory, which is our medical unit, they have, as of 2 weeks ago, 70% vaccination rate. If you're looking at maybe in the east, you're looking at 34% vaccination rate. If you're looking in the west, you're looking at 40% vaccination rate. Now, as far as how many's had COVID, I certainly will get you that number. I didn't prepare that.
Thank you very much. I'd appreciate it if you could get that information to me. And one final question. Thank you, Mr. Chairman, for a little leniency here. Have there been any conversations about attempting to make vaccinations mandatory for staff?
I have not had any conversation.
Thank you. Thank you, Mr. Chairman.
Representative Lockett.
Yes, thank you, Mr. Chairman, and thank you, Mr. Johnson, for stealing part of my thunder. I do appreciate that as well. I have a couple questions. One is, can you describe or tell kind of what the policies and procedures are for providing PPE to the staff?
Yeah, early on, we prison industries, and I don't know if you all realize that, made masks for our population, and so inmates are issued masks that were made by prison industries, and that's interchanged anytime that they need it. Staff were issued KN95s, and they can also get masks as they need it.
So in terms of the PPE, then that's an ongoing effort. So as it's needed, they are provided
Yes.
that.
Yes.
Okay. And one more question as well. And I guess this is more of kind of your opinion, and I do appreciate your testimony. I thank you for your obvious caring about your staff. So my question goes to staffing, and you mentioned how low you are on staff. And so my question is do you feel like your staffing issues at this current time are a matter of because of COVID? In other words, do you see that people are kind of scared to be in that environment, and so therefore they are not wanting to apply or be on staff at a correctional facility? Or is it due to pay or some other possible reason that you see?
Sure. I think in the height of COVID, people were worried about their families, and it's rightfully so. I think that going into, and I don't want to blame it all on the pandemic, but I will say that going into, we were 20%. But COVID did a damage on us. I mean, when you're looking at, you're making $20,000 to $30,000 a year to come in and take the pandemic out of it, and you're spit on, you've got crap thrown at you all the time, or somebody cussing you or assaulting you, and you got that low pay. Then you add COVID on top of it, which can be life-threatening more than what they're used to, and they're working those long hours because people had either had COVID or been exposed to COVID, or that they were on FMLA for some other medical reason. And you're having to fill in those spots. People got tired, and it is about money, and it is about COVID, and it is about not having enough staff that you could have a vacation, that you could take off where you want to, that we can get officers back down to their 8-hour shift. It's a combination, it's a storm that happened. And this is the end result of this storm.
Yeah, and I appreciate that. And again, I appreciate your passion. Thank you, Mr. Chairman.
Representative Moser.
Yes, thank you, Mr. Chairman, and thank you very much for your very compassionate testimony. I can see that you really do care about what's going on, and you're working hard to really rectify some of the situation. I think I should have posed my question about how DOC is utilizing the vendors who are currently contracted to provide substance use disorder treatment for inmates, especially in response to the COVID issue and overcrowding. Can you just fill us in on kind of what's going on with that?
Well, I think the question was that we have 1,570 DOC SAP beds in 19 jails. And I would have to get you more information, but I think that all of them are filled, if that's what you're asking.
Well, I know that there are some contracts, contracted vendors outside of the jail, like VOA and some of the others. I don't know if the plan was to move inmates out to those residential facilities or to bring VOA in to provide some of those services. But either way, I just wonder if that's being utilized in either of those scenarios.
Yeah, those are being utilized to the best of our ability.
Okay. And I would assume that COVID has played a part in the ability to move people in and out. That's consistently what we're hearing.
I think COVID slows your process down. When you add in that 14 days of having to make sure that this person is not going to convert, then yes, it slows the process down. I sort of think that sometimes when inmates are leaving, and because of this pandemic, it may have caused some people to reconnect with their family. and inmates going home to their families as opposed to, going to halfway houses and staying. So.
Okay, but we're not sure that they're getting substance use treatment.
Yes, they are. I was just adding that caveat to it. I'm sorry, I didn't mean to confuse you.
No worries, no worries. Mr. Chairman, I have one more question, if I may.
Go ahead, Representative Bowser.
Thank you. There's a treatment available for individuals who convert, who do test positive if they meet certain criteria and are caught in the first few days. It's called Regeneron, or the monoclonal antibody infusion. And this is also something that can be given subcutaneously. Is this something that the DOC would entertain trying to get grants through or obtain the Regeneron for anyone who tests positive? Because this is being shown to reduce those severe illnesses and hospitalizations. Is this something that you all would consider?
Actually, we did use part of that treatment at KSP back in March. I guess it would have hit right in April. We partnered with the local hospital and public health to do that in the institutions. But yes, we would utilize that.
Okay, I would love to see that program really expanded, because we don't want to see folks succumb to this COVID, either Alpha or Delta, any of the variants. I mean, we think that they're probably getting more virulent, and we have this treatment available. I think we ought to utilize it. So if there's something that you need from any of us to help create those partnerships, or certainly you can obtain the information too. We're happy to help.
Well, actually, our pharmacist company keeps us up to date, and they have that on shelf if we need it.
Perfect. Okay. Thank you.
Senator Alvarado, did you have a follow-up to that?
Just very quickly, thank you, and Commissioner, thank you. I've been listening intently to all the questions that are being asked, and I think the numbers about how many people have actually had infections, I think, is poignant and important. We often talk about vaccinated and unvaccinated. I think some of the discussion needs to be about immunized and unimmunized. CDC recently has put out reports talking about people that have had a natural infection. If they have an adequate amount of neutralizing antibodies in their system, that often is better than getting vaccinated sometimes. Now, we don't want people to catch the virus, understandably. If you haven't had the infection, you need to get vaccinated. I'd encourage anyone who has not been infected, please go get a vaccination. Even some of those who have been may not have an adequate antibody response and should get a vaccine as a booster to get your immune level up. We'll have more of this discussion in our Health and Welfare Committee tomorrow. For those of you who are members, you'll be hearing all about it. For those of you who are not, I'd encourage you to tune in. We're going to have a bit of a discussion on this and on monoclonal antibody therapy as well, which I think you want to take that once you're diagnosed and don't have the acute illness. Once you get sick enough to be in a hospital, it's pointless to take it at that point. And Commissioner, when you were talking about people, I think where your words were being spit on, throwing crap at you, being called names, being physically assaulted, I thought you were talking about our nursing home world, which is what I work in every day as well. And that's a very similar environment to where we're struggling mightily to have staff to staff our nursing homes, which are about 36,000 clinical beds in our state. And it's a struggle right now for a lot of those. So it's not only just in our jails. I think it's in so many levels of service that we have that we provide for people that are vulnerable as well. So, Mr. Chairman, I appreciate it. I just would encourage members to tune in tomorrow. Thank you.
Thank you, Senator Alvarado. We do still have several questions. We've got about 15 minutes left on the agenda, so if everybody could be brief with their questioning as we lead down this final path. Representative Thomas.
Thank you, Commissioner. We appreciate your testimony. Up till just the last couple of weeks or so with the Afghanistan issue, it was hard to not turn on our TVs without seeing the influx of non-U.S. residents coming across our southern border. We see them coming in. We realize a lot of them might be sick. A lot of them might be carrying COVID. It's hard to get any data out of there. I know you all keep really good statistics to the Department of Corrections. Can you let us know the statistics of, say, 2020 of how many non-U.S. residents ended up in the correction system,
and then maybe give us a comparison of 2021. And I realize this is something you probably have not brought with you today, but I would be interested in seeing exactly how many non-U.S. residents are in our prison system this year compared to last year. And then if so, how many might be tested positive for COVID?
I sure will.
Thank you.
Representative Tipton.
Thank you, Mr. Chairman. Commissioner Cruz, I appreciate you taking your time to be here with us today. It certainly adds to our perspective as we consider all these issues. And I just want to clarify some of your testimony. The question was asked, or you may have brought up about the number of inmates in the system who have been vaccinated. And I believe the number that I saw was 83.02. And I assume, and I know inmate populations vary, so I assume that is maybe a current rate. Could you verify that? And also I have a question on, we have state prisoners in local jails. Do you have specific numbers on the number of those prisoners who have been vaccinated? And could you just give us a general perspective on what our inmate population is today versus when this began 18 months ago, and where our capacity is right now? Thank you.
Okay. The first question is 83.02 is the vaccination rate based on today's count. You know, the count changes at midnight. What was your second question? Sorry.
I apologize. I tried to get them all in at once. On the number, we have state prisoners in local jails. Do you have any kind of statistics or data on how many of those prisoners are vaccinated?
I do not. I usually don't obtain them until they actually come into the institution, and we go to the registry to see if they've been vaccinated.
And my last question was, could you give us some comparison on inmate data of when this started 18 months ago, March of 2020, versus today, and what's the state's capacity is for if we were to have an influx of more prisoners? Where do we stand at on capacity today?
Are you talking about in March of last year?
Yes, for March of last year. I know I believe there were some prisoners maybe were released last year. So I just want to know where our capacity numbers are from then versus today.
I can't give you the capacity of last year, but I can get it for you. But I can tell you what the capacity today is that we're at, the number that I gave you was based on 10,027. That 83.02 is based on that number. We currently have 1,645 inmates who are unvaccinated.
And I believe that the population in March of 2020 was approximately 12,000. We'll confirm that number and get back to you, but that's what my memory, that's what I remember from March of 2020.
Representative Koenig.
Thank you, Mr. Chairman. I asked the previous speaker about the policies for visitation and was hoping you all would address that in your remarks. Can you tell us, they seem to think there's some ambiguity in it, so can you make it clear what the county visitation policies are from your perspective?
Yes, so there must be some misunderstanding with the previous person who provided testimony. But the Department of Corrections, of course, does not run the county jails, and we cannot tell the jailers how to run the county jails. So there was some guidance put out, and of course, the Department of Corrections works very closely with the Kentucky Jailers Association to share information and guidance that we were utilizing in the state prison system. And there was a memo sent out by the KJA that talks about it's a guidance, it's suggested guidance that is strongly encouraged, and it included suspending all visitation within your facility. Again, that memo was not from the Department of Corrections, it was from the Kentucky Jailers Association, and it says for questions, you can contact Renee McDaniel, KJA Executive Director. So that was a suggested protocol sheet sent out by the Kentucky Jailers Association. Additionally, in March 13th of 2020, there was a email sent out from Renee McDaniel, again, from the Kentucky Jailers Association, where she put several different pieces of information together in one email. It included the memo that I just mentioned that provided, suggested guidance and strongly encouraging limiting visitation. It also described some guidance that had been put together by the Justice and Public Safety Cabinet, along with the Kentucky Public Health Department, that again talked about suggested guidance and for correctional facilities. And so one of the things that it says in there, again, is to limit or restrict visitation. But that, it says we recommend visitation to prisons be suspended until further guidance is issued. So this was the Department of Corrections sharing its own policies and protocols with KJA that KJA then sent out to the jailers. But
Can I interrupt?
Visitation.
I know we're short on time. What is the policy today from the Department of Corrections?
We have opened up our visitation to people that are vaccinated for the inmates.
And you have no direction for counties. Is that correct?
That would be at the
Thank you.
prison.
Just a very brief follow-up on that. You did mention that there was public health guidance and guidance from the Justice and Public Safety Cabinet that memo was based upon. Is that correct?
Yes.
That memo cited.
I'm sorry?
That memo cited guidance from the Justice and Public Safety Cabinet and the Department of Public Health. Is that correct?
There were 4 pieces of information provided in Renee McDaniel's email. One of them was the memo from KJA itself, providing this strongly encouraged guidance. Another was a sheet of paper from the Department of Health and the Justice and Public Safety Cabinet talking about suggested guidance for correctional facilities.
And I think that's the ambiguity that was mentioned by Representative Koenig in his questioning, was if there was guidance issued by the Department of Public Health and the Justice and Public Safety Cabinet, it seems as though the Jailers Association was working off of those guidances listed there.
I agree. There was some misunderstanding here based upon the information that was sent out, because it's very clear from this guidance that it is not a directive from the Department of Corrections.
Senator Webb.
Thank you, Mr. Chairman. I just have a couple things real quick. Those of us who's advocated for our CEOs all these years certainly realize that we don't pay them enough, COVID or not. So we've got some issues to address on those staffing issues, because they truly are risking their life, as y'all have heard today, and they always have. So that's not changed. But my question is, when did vaccination of our inmates in our institutions start?
And I will clarify that, but I believe that the 60 to 80, the first time we did vaccinations for them, I think was in March of this year. And then the rest of the population was in April or May. But I'm doing that from memory. I'm sorry.
Well, I would like to have seen it all done sooner. I had a lot of clients and individuals calling me, and actually I didn't get my shot. I was sort of a protest until our inmates had the opportunity to be vaccinated. So I would just ask, what is that opportunity now? Are they on entry, or what kind of information do they get? Is it voluntary and all those things?
Yes, it is voluntary. People that are coming in intake are offered the vaccine if they haven't gotten it in the jails. We are a provider and can administer those now. They are given one-on-one information about what it means to them as an individual in taking the vaccine or not taking the vaccine. So yeah, we try to go and say, because you as an individual, here's what's happening in your healthcare. Here's why we recommend that you go ahead and take that. But I do want to say staff got started to get vaccinated the first of the year with our local health departments.
Okay, one more quick thing. How about reporting? I know we've had some issues on state, we're responsible for state inmates. I don't care where they are. And notwithstanding the challenges of the local jails that we've heard about earlier and didn't hear all of it, their challenges, but certainly we've had some reporting issues when it comes to state inmates early on. Have those been remedied and are we getting the accurate data for our state inmates that we're responsible for that are in the county jails?
I don't want to answer this incorrectly, but I certainly will make sure what my answer is correct and get back to you.
Okay, thank you. Thank you, Mr. Chairman.
Representative Tate.
Thank you, Mr. Chair. Commissioner, can you please describe for me how COVID has directly impacted your ability to deliver services to your inmates?
Well, early on during the pandemic, we had shut just about everything down. And we have now opened up where they can go back to school, they can continue on their jobs. The only time that we would interrupt that is if we had another positive that's come through the institutions. But we've restored all of our programming and education piece as of now.
So can you please describe like approximately how long those services were shut down?
We went down in March and we brought about a year.
Thank you.
Senator Southworth is our last question from the panel, and then I've got one final one from me.
Thank you, Mr. Chairman. I want to roll through a couple of pieces here relating to the visitation. You mentioned visitors who were vaccinated or allowed visitation, but not others. What about the inmates? Are the inmates able to have visitation regardless of their vaccine status?
Yes, ma'am.
Okay, and for those visitors who have a severe religious objection to the vaccine, is that covered in the classification of who's vaccinated?
I'm not sure I understand your question.
So in certain cases, like for example, in teachers, when we were looking at who's vaccinated, health, nursing home workers, so forth, those who have exemptions count in the total number of our vaccinated number when we're looking at are we fully vaccinated? Is that being included, is like a religious exemption, for example, in the numbers of or in the classification of visitors who are able to come?
Here's what we started out, and I just kind of want to let you know what my plan was, is that when we reopened up visiting, we had just people that were coming in to be vaccinated. I wanted to, before this variant came through, I wanted to be able to add the children to it and then work our way down to the unvaccinated, just to make sure that we were stable. Because we're coming off a lockdown and then you're adding more people in. And I haven't gotten to that piece yet.
So you're saying children are not able to come because you're not to that level?
Right.
So can you explain then to me why I get a constituent request relating to the inability to visit with a child on a Zoom video if that's not in-person visitation?
Are you saying that the inmate can't visit with the child?
Correct.
I'm just having a hard time hearing you.
Oh, I'm sorry. Yeah, if an inmate has a child that they were visiting with and the child's unvaccinated and now they're visiting on Zoom and now the child's not allowed to be seen on the screen during visitation, I'm just hearing things about visiting lists getting limited. I'm trying to figure out how that's happening.
That shouldn't be. They should be able to visit with them on Zoom. I would, if you could share with me who that was, like offline, I can make sure that this is not happening. I can tell you that we are going to get better with our visiting. I don't want people to think that that's all the inmates are going to ever be able to do, is to be able to visit in that square box, because that's not happening. My plan is to fully restore visitation, because that's important. It's important to the inmate and it's important to the family. But it should not be happening where that child cannot visit with their mom and dad.
Well, and I appreciate that. I think it's actually like a niece or a nephew situation, and that was one of the issues on who can be on the visitor lists and who has to be on the visitor lists and so forth. But we definitely can follow up. Thank you.
Ladies, my final question. Obviously, we've talked a little bit about the large number of state prisoners that we have in the custody of local jails. And we have some jails that are very, very well equipped to space people out here, there, and other places to deal with quarantines and to deal with positive populations and things of that nature. Have there been any requests from local jails with regards to state inmates that may be in their facilities that there may be an overcrowding issue and some of those smaller jails are not able to space people out, and they've asked for help with regard to trying to get some movement done so that they could space people out properly? And how have those requests been responded to?
So early on in COVID, when there were several jails that reached out to us last year that we brought our state inmates in. One that comes to mind, Nelson County couldn't, their smaller jail could not quarantine like they should. And we brought the state inmates in, quarantine them, test them. And when Nelson County was able to come back up, we shipped them back out to them if they qualified for that program. From time to time, we do get jails that reach out to us and say, "Hey, look, we got an outbreak. Can you get inmates?" I've been on phone calls with jailers when we were sitting and talking about their COVID issues and have offered, "Do you need me to take anybody?" So we have had that give and take situation through COVID, because really, they are our people.
All right, thank you very much. Seeing no other questions at this time, appreciate you all making your presentation. Do I hear a motion to adjourn? Got a motion, second. All in favor? Aye. We're adjourned.